Good afternoon, all. We're here for an appeal hearing in the matter CA-11-2016 before the Chief Justice Michael Hwang, Justice Sir Jeremy Cooke, and His Excellency Justice Omar al-Muhairi. The appellant is represented by Herbert Smith Freehill. Lead counsel is Andrew Hockhauser, QC. The respondent is represented by Hadif and Partners. Lead counsel is Akash Naubat. Assisting is Jamie Liddington.
Hi, Mr. Hockhauser. Just to confirm,
I am from Essex Court Chambers.
your opponent is aware that I am also a door attendant at Essex Court. Please carry on, Mr. Hockhauser.
May it please the Court, this is the hearing of an appeal from the order of His Excellency Justice Al-Madani. It is dated the 14th of July of 2016, and the judgment was handed down almost 1 year after the trial, which took place between June and August of 2016. Closing submissions, you will see from the front of the judgment, were on the 2nd of August of 2016. I represent the appellant, Elseco Limited, which I will refer to as Elseco. My learned friend, Mr. Akash Naubat, appears for the respondent, Mr. Lees. As the Court will be aware, the case concerns a claim by Mr. Lees, who was the former Chief Financial Officer of Elseco, who, following the termination of his employment on the 11th of February of 2014, alleged that he had been dismissed without cause or notice. Elseco relied upon Article 59A of the DIFC Employment Law, number 5 of 2005. I will refer to this as the employment law. And they maintained that the dismissal was for cause. The grounds for termination were set out in a letter from Elseco dated the 17th of April of 2014, which is to be found in Volume A, tab 20, and I will take your lordships to it later. The learned judge found, first, that the dismissal was without cause and that Elseco could not rely upon the provisions of Article 59A. Secondly, he awarded compensation to Mr. Lees for some, but by no means all, of the sums that he claimed. And those are set out in the judgment at A, tab 4, at page 46. He details those in the order that he made. Thirdly, pursuant to Article 18.2 of the Employment Law, the learned judge held that it was mandatory to impose a statutory penalty payment upon the defendant equivalent to Mr. Lees's last daily wage for each day that the defendant, Elseco, was in arrears. He did this despite the finding, if you could turn please to paragraph 165 of his judgment, which is in volume A, tab 4 at page 83. He said in that paragraph, in my view,
Paragraph again, please.
paragraph 165. In my view, the wording of Article 18.2 of the Employment Law can lead to absurd and harsh consequences, especially where the conflict between parties reach the court. This is made even worse if the dispute itself is over wages. Pursuant to that article, he awarded Mr. Lees a daily wage of some €297 odd for each day that Elseco was in arrears. And as can be seen from the calculation contained at paragraph 88 of our skeleton, this is at volume A, and it's at page 171.
Paragraph number?
The paragraph number is paragraph 88. This was the opening skeleton.
28th of July.
Correct. It's dated, my lord. The opening skeleton is at tab 9. This is at the Court of First Instance, and the sum that was being claimed by the claimant was at that stage €297.35 since the 12th of February 2014. So the sum that was awarded by the judge as representing the daily wage was that was then pleaded and claimed by the claimant. To date, at the date of judgment, that amounted to some €262,000. So although, as you will hear, there was only 3 days left for the employment to run, the sum that has been awarded as a penalty, as at the date of judgment, amounted to €262,000. See our skeleton before the Court of Appeal, which is at tab 3, page 12 of volume A, paragraph 10C.
Sorry, paragraph what?
Paragraph 10C, my lord. He also awarded interest at the rate of 1%, and that is apparent from paragraph 11 of the order, which is in volume A, tab 4, page 46. The order in the judgment that appears at page 46, you will see that prefacing the reasons for the judgment, the order begins starting at 46, and the award of interest is at the foot of the page. Your Honor, do you have that?
No, I'm looking at the judgment, or should I not be looking at the judgment?
You should be looking at the judgment. You'll see that it begins at page 43.
I'm not working from that, Manzo.
Well then, internal pagination 3. And it's paragraph 11. Does Your Honor have that? The foot of the page.
Yes. Sorry, the interest?
So you'll see that you've got at 10 the award of 297 odd euros, and then interest at the rate of 1%. Elseco sought permission to appeal, and that was granted by the Chief Justice on the grounds that the issues that have been raised were issues of public importance. The amended order is at volume D, tab 1. As correctly identified by my learned friend in his skeleton, our appeal raises 2 issues. Did the learned judge err in law in his application of Article 59A of the employment law to the facts and circumstances of Mr. Leese's termination? Secondly, did the learned judge err in law in his construction of Article 18 of the DIFC employment law? Now, you will no doubt have seen the notice of appeal, which is at A1. The grounds of appeal are in Volume A at tab 2, and the skeleton in support is at Volume A, tab 3. In addition, Mr. Leese has cross-appealed on 2 issues. One, despite having asked for and been awarded the daily wage of €297.35, as the judge did in paragraph 10, he now seeks to increase that figure to €831.69 a day. And he does so seeking to take account of a bonus that was not awarded or payable until June 2015. If you look, please, at the judgment at paragraphs 100 to 102. Could I ask you just to read those paragraphs to yourself? It was the defendant's position that the sum was not payable until June 2015, when it had finally determined the paid profit commission for the 2013 underwriting year, and it could not determine the final figure until the valuation of the insurance claim by one party was known. And then at paragraph 102, until the 2nd of August 2015, and by the way, I paused there to correct an error on the front page of the judgment, which recorded the closing submission as being the 2nd of August 2016, where it should be 15. The defendant submitted its second written closing submission, and it was said that the defendant failed to update the court with respect to the exact value of the bonus. That should have been known by 2015, and therefore the bonus was awarded by that time in August. It was known. I will address your lordship on the cross appeal in due course when my learned friend has had the chance of opening it, but I simply outline the parameters of this dispute. So in the cross appeal, there is the calculation of the daily wage, and there is also an uplift sought in the rate of interest from 1% to 8%. And he does so on the basis that in their pleadings for the claim and counterclaim, that was the rate advanced by the parties. His Excellency Judge Muhairi granted Mr. Leese permission to appeal on the 9th of October of 2016, once again on the ground that the issues raised were of public importance. And that can be found in Volume D at tab 5. Now, could I ask the court, what have you had the opportunity of reading so far? There were 2 suggested lists, one at the front of my learned friend's skeleton, and the other as an appendix to our supplemental skeleton. First, could I inquire, did you receive the supplemental skeletons?
If it's in the bundle.
It won't be in the bundle. It will be separate because they were filed after the bundles were lodged.
Speaking for myself, as of today, on the desk today, never seen before.
Right. Well, obviously that is unfortunate, and I apologise, but it was filed with the court some time ago. You will see at the back that there is a suggested reading list. Is that, again, something that you haven't had the opportunity to go through?
Actual, up to the extent that I had already elaborate on them, fine.
I will. I'll obviously. Do I assume that you've read the original skeletons and the pleadings, the notices of appeal, and the judgment? That's very helpful. Could I also ascertain, my learned friend has filed a skeleton, a supplemental skeleton. Have you received that as well? Again, only today. Well, I will obviously bear that in mind when I'm making my submissions. The appeal is listed for today and tomorrow, and if I could come to the trial timetable, there has been, in principle, subject obviously to the approval of the court, a timetable that has been agreed. Could I pass that up? Your Honours will see that it is proposed that today I outline the submissions relating to my appeal. And that will take the rest of the afternoon. I note that this timetable is due to finish today at 5:30. What is the usual practice of the court, Your Honours, as far as sitting is concerned? Bear that in mind.
Bear in mind is also, I was wondering how you could take 1.5. Why do you need 1.5 days? For 2 points is an injury. Thirds of this bench has already heard arguments on Section 18. Quite quick on the.
All right. Well, I will take the arguments as quickly as I can. Obviously, in relation to the first issue, Article 59A, there is quite a lot of underlying factual matters that I would wish to draw attention to, particularly if you haven't seen the supplemental skeletons. So I hope that...
Focus on that part of the case. A lot of the arguments that I've seen in your skeletons on 18.2 have been made in the other case. I don't know whether you realize the front line has already been before the Court of Appeal in the last session. So we have finished, out of the 3 judges here, sat on that panel.
Well, Your Honour, that's very helpful because I realised that Frontline was going on appeal. What I didn't realise is that the actual hearing had taken place. Yes. And that took place at the last session, did it? Yes. I'm very sorry, I wasn't aware of that.
At an advanced state of drafting, subject to whatever other nuggets that we will glean from today's hearing, and what we were proposing to do. After this hearing, finish the frontline decision, get it out to you for final written.
Well, that's very helpful. And I will obviously bear in mind that you've heard substantial argument on the ambit of Article 18.2. I turn...
On your first point, is it really that you say the test was wrong rather than facts?
Well, Your Honour, it goes further than that. There are 2 limbs to what I say. The first is that it was a threshold that was set too high. That's point 1. Point 2 is that when you look at the events of the day that took place, the whole conduct had to be looked at in context, in the round. And this the judge did not do. He failed to look at the totality of the contract against the contractual obligations which receive faint attention in the judgment. And what I was going to do was to take you to the background and then focus on the events of the day and to show you how the judge addresses it in his judgment. And without intending any undue criticism of the learned judge, there is a difficulty when you come to deliver a judgment a year after hearing the evidence, and that there are many salient facts in my submission that were omitted from this judgment, and one very important one when one comes to consider the analysis that he applies. And my criticism is that he tends to isolate individual items of conduct and then set a yardstick. Does that strike at the root of the relationship? Answer no, move on. And it is said by my learned friends, if I can advance my submission a little, that he only found that there was one ground made out, and that was the removal of the laptop containing the confidential data belonging to the company. It is my submission that when one analyses this judgment, that is not the position. And I will invite you to look at it in the round, and that is the second limb, and that will entail, Your Honour, some factual investigation.
Test, and then you have to show us that you made a difference. By
Correct.
looking at all the facts.
Absolutely. Absolutely. And it is my submission that when the proper test that is laid down in Article 59.2 is applied against the what were effectively facts admitted and facts found, and facts admitted that were not in the judgment, that there is only one conclusion that one could have come to with this senior employee behaving as he did on that day. So, a little background, if I may. Mr. Lees and Mr. Laurent Lemaire, who was and remains the CEO of Elseco, founded the company in 2007. It was a start-up company that was incorporated in the DIFC, and it is engaged in the business of insurance, intermediation and management. Mr. Lees was employed as the CFO, the Chief Financial Officer, and its chairman. Although there was a dispute between the parties as to precisely when he assumed those positions, but that was not resolved by the judge. It was not necessary for a resolution of this dispute. In January 2009, Mr. Lees and Mr. Lemaire jointly purchased the entire shareholding of the company. And thereafter, on the 13th of June 2011, those individuals and the company, Elseco, entered into a document, an agreement, entitled a Sale and Cooperation Agreement. That, in my submission, is an important document because it sets the contractual background against which what happened in February has to be viewed. Could you take that document up? It is to be found in Volume A at tab 15. You will see that although this is headed draft 13th of June, this is the document that was entered into. The parties are cited at the front page, page 258. If you look, please, at Clause 2, at page 262, Mr. Lees was selling the entirety of his shareholding to Mr. Lemaire. They are referred to as the transferred shares. At Clause 5, page 263, the consideration is there set out. And you will see that there were a series of installments that were to be paid in accordance with Clause 5, and in particular 5.2. You will see in each case of the subparagraphs A to D, there is a reference to retained earnings. Retained earnings is a defined term at page 261. and you will see it's by the second hole punch. It means the aggregate of the amount of the consolidated capital and revenue reserves of the company for the relevant financial year as set out in the audited accounts of the company for the relevant financial year, calculated using the same method of calculation as the one used for the 2010 accounts. So that is an important aspect of this agreement, the method of calculation by reference to the retained earnings as defined. Moving on in the agreement to page 266, the conduct of the business and organisation was there set out. And clause 9.2 is an express term which is particularly important because, as I will show you, Your Honours, it was common ground between the parties that the SCA governed the employment relationship in February of 2014. I ask you, please, to bear that in mind. Clause 9.2 provides P.E. Lease and L. Lemaire agree to act in good faith in relation to the management and conduct of the business, which includes, without limitation, procuring that the company carry on the business in the ordinary and usual course. Now, significantly in my submission, that term does not appear in the judgment. No reference to it is made. You will see in the body of the judgment that there is a reference to the SCA and looking at the judgment itself, again I will refer to the internal pagination. First, starting with the claimant, paragraph 3.
A minute, please. Paragraph? Which paragraph?
Paragraph 3, Your Honour. You'll see it says the claimant alleges that on or around the 7th of May, the claimant and the defendant entered into an employment contract. And then he deals with the appointment as CFO, director, and chairman. He then, what he doesn't deal with is what was pleaded at paragraph 5 of the particulars of claim. This again is an important point. If you turn, please, to tab 6 of volume A, because the case that was pleaded, and as far as I could see, was adhered to at trial, you'll see in paragraph 5 there is reference to the employment contract of 2007, but it then says the terms of the claimant's employment, this is some 6 lines down, were varied by Appendix 2 of the Sale and Cooperation Agreement dated the 13th of June 2011. So it wasn't just the 2007 contract, according to the claimant, it was varied by the SCA. It was going back to the judgment, paragraph 9, the defendant relied alone on the SCA. And just for your note, that is to be found in the defence at A tabs 7, page 100.
Paragraph 9 of the
Paragraph 9 of the judgment, which is internal page 7. The judge records the defendant denies entering into any contract of employment with the claimant other than the SCA. Now, again, the attention that is given to the SCA in terms of what contractual rights and obligations Mr. Lease was subject to is not given great attention in the judgment. If you look back to the page number 5 The paragraph 5 refers to clause 8.2.
Of the judgment?
Yes, it refers to 8.2 of the SCA. And there is reference to the methodology calculation by reference to the retained earnings figure at paragraph 11. But clause 9 receives no attention at all.
Help if you tell us what attention he should have paid to it.
I beg your pardon?
Help us now, instead of keeping us in suspense, tell us what is the significance of 9.2.
Well, because it is quite clear that when examining the conduct, the test that is laid down is whether there has been a breach of contract or the circumstances are such that a reasonable employer would terminate. Now, if there has been a breach of clause 9.2, and I will address you on the ambit of it in due course, then that clearly would be a matter that could and should have been taken into consideration. The fact that that obligation receives no attention at all in the judgment is, in my respectful submission, an omission, because it is a clear term to which he was subjected.
But it's a term between two shareholders in their capacity as such.
With respect, it is not, because if you look, this encompasses far more than just the shareholding relationship. If I can continue with clause 9, I will make that submission good, Your Honour. Looking at clause 9, you will see that the agreement to act in good faith in relation to the management and conduct of the business and express reference to the office on which they hold quite clearly indicates that this extends into the employment relationship.
But where is the reference to the office? 9.3, I suppose.
9.3 refers to the office. 9.4 indicates the date of resignation of chairman. But please look at the two appendices, because 9.5 refers to the responsibility for the business being divided amongst Mr. Lees and Mr. Lemaire. Now, it's a reference there to Appendix 2. I believe that that is wrong.
So far, it's still a shareholders' agreement.
Please, can I make the submission good, and then I will answer your question. If you look at page 273, Appendix 2 is entitled Appendix Salaries, Employment Contracts. And in my submission, the combination of that and 9.2, which obviously applies to the employment relationship to which the company is a party, this is the document that was relied upon both by the claimant and by the defendant. It is referred to in the judgment, but the clause of good faith, which in my submission would be implicit in any event in law, is one that is expressly agreed between the parties. Furthermore, if one looks at Appendix 3...
Just interrupting you slightly, remind me what is the governing law?
Well, there was a jurisdictional issue.
French law.
There was a jurisdictional issue on this, but there was no specialist law evidence that was produced at trial.
Some of us do know a little bit about French law, but it's 19.2, right?
Yes, but with respect, Your Honour, there was no expert evidence that was given that French law in this regard would be any different to DIFC law.
You're going to rely on the English presumption that if you don't give evidence of foreign law, you just follow English law?
Well, the court had no evidence to the contrary.
No, I'm just asking you a question. Is that your position?
That is my position.
Yes. And then you'll have to address us on the applicable law of evidence in the DIFC in due course.
Well, my Lord, I will endeavour to do so. Obviously, I'm not as familiar with this jurisdiction as you are, but my understanding was that this was a matter that came before Sir David Steele, and there was an application by Elseco that this should be a matter that would be heard in the French courts, and he rejected that, one, on the grounds that the application was made too late, and two, on the basis that here he was of the view that this matter could be properly heard in this court. There was no application for expert evidence of what French law would amount to, and therefore I am relying on the plain wording of 9.2 as a contractual provision which imposes a good faith obligation,
Okay, so
which in my submission I'm perfectly entitled to.
Nobody is denying your entitlement to make whatever submission you want to. I'm just trying to understand your point of view, where you're leading us. And my question is, therefore, you are saying that we should interpret this obligation of good faith in accordance with the English common law understanding of that term, such as we can make out.
Well, I'm asking you to look at the...
I probably know more what good faith means in French law than I do what it means in English law.
Well, you have the advantage over me, Your Honour, because I'm afraid I don't.
But you are going to lead some cite some case law on good faith then?
Well, I am. That's exactly
Okay.
that's exactly what I propose to
Fine.
do. And in fact, for that reason, bearing that point in mind, I didn't quite realise it was going to arise in this way, but I felt that it would be of some assistance to address you on the good faith obligation, as I understand
Where
it.
you're coming from is important to
Yes.
flag that early. Thank you.
So my submission is that the judge doesn't decide what the contractual documents are in terms of the employment relationship, but from the pleading, it is clear that both parties relied on the SCA. In my submission, correctly so. When one looks at the ambit of this document, it is a comprehensive regulation of the employment relationship, the division of responsibilities within that employment relationship of the CEO and the CFO, the obligation of good faith that is imposed under 9.2, and that must arise beyond mere shareholders and imports into the respective employment contracts of both Mr. Lemaire and Mr. Leese. And as I say, conspicuous by its absence from the judgment is the reference to 9.2 itself, although, as I say, there have been other provisions that are there identified.
At some point, when it's convenient, you might want to show us your pleadings and to see how you plead 9.2 in relation to its status as a contractual term between the claimant and the respondent.
If you look at page 100, A tab 7,
Of
this is the volume A tab 7, page 100. This is the defence. And that it expressly refers at the foot of the page in 5.4, page 100. To the obligation to act in the best interests of Elseco to maximise shareholder value and ensure a smooth transition of the business.
5.4?
5.4, Your Honour, at page 100.
Going over the page, okay. Well, the pleading there simply recites the terms of the SCA.
Yes, and then they recite the breaches later on in the agreement under the termination of the engagement. Starting at termination of engagement, starting at paragraph 6.
There's a reference to the SCA under 6.1, a reference to or the breach of any particular
The
6.12, I see something.
No, there is simply a pleading that it was a termination for cause. Yes. In the pleading itself, that is the entirety of the statement of the defendant's case. So there is no direct reference to a breach of 9.3. There is simple reliance on 59A. But if you look at tab 10, the opening skeleton for trial,
Say tab 10.
I did, Your Honour. The terms relied upon appear at 176. And also the duty of good faith and fair dealing under the DIFC contract law.
This is the
24, there is no requirement to establish dishonesty on the part of an employee in order to prove breach of a duty of good faith.
yes. After we part from paragraph 17, where were you? Or you?
I am.
Right. Okay.
And then what is said, because remember, the test that one has to apply for Article 59A is, was this a termination for cause? And was there a circumstance in which a reasonable employer would have terminated for cause? That is the test that has to be satisfied under Article 59A. Now, when determining that, one looks at the contractual backdrop that there was. These are clearly identified as being relevant factors to take into account. And as I say, there is an express obligation of good faith, and one that would be in any event implicit, the trust and confidence obligation, as a natural incident of the employment law within the DIFC.
The IFC is not the government.
The relationship here is one that is governed, I accept, by French law under the SCA. And given that there is an express clause, there would be no need to imply one because it exists on its own. It's self-standing.
You don't need the DIFC.
I don't,
contract law.
absolutely. I have an express term under 9.2 that I rely upon. And my point is that is important when one comes to consider the events that occurred. Now, that is particularly so because the SCA provides that Mr. Leese was to be paid to his shares depending upon the amount of the retained earnings for any particular year. And that made absolutely plain that they had to use the same method of calculation as that was used for the 2010 accounts. So for this last year, that applied just as much as it did for all the years that preceded it. Now, the judge, in his judgment, makes a finding at paragraph 65A. Where he said the employment relationship, that's internal page 21, Your Honour.
Paragraph? Oh, internal
Paragraph
page
six-
21. Yeah. Paragraph?
Paragraph 65A. Now, he is considering at this stage the removal of the computer. Now, I will address you on that aspect in due course, but there's a point that he makes here that I, at this stage, would particularly like to highlight. The employment relationship in this case, he says, is not an ordinary one. The claimant, apart from being CFO, board member, and co-founder of the company, along with Mr. Lemaire, had a special interest in the company's final accounting years, in which he was to receive a percentage of the company's profit as a final payment against the sale of his share in the company to Mr. Lemaire in accordance with the SCA. Now, we rely upon those facts when...
Just to interrupt the point of fact, by this time, Mr. Lemaire was the sole shareholder.
Correct.
And the amount that would be paid to ended on this accounting exercise would be paid by the company or paid by Mr. Lemaire?
It would come from the retained earnings of the company.
It would be paid by Mr. Lemaire, who was the purchaser of the shares.
Yes, it would. So what would happen is that the retained earnings would be transferred to Mr. Lemaire. Mr. Lemaire would pay those over.
Carry on, please.
We rely upon those facts when considering the conduct of Mr. Lees. He was in a particularly important position. He was a senior employee. He was a director of the company. He was somebody who was expressly charged with acting in good faith in relation to the management, conduct and transfer of the business.
At that time?
I beg your pardon?
Was he on a salary?
Yes, he was.
Was an employee and not a consultant?
Absolutely. No. He was under salary, and he had an entitlement to a bonus, an end of service gratuity. So he was an absolute mainstream employee. Now, at this point, I would like to refer you to two decisions on the issue of good faith, if I may. They're not in the bundle, but since I thought that it may be a topic we should consider, could I pass up? And we have three sets. Same order for all three. Thank you very much. Sorry. Thank you.
It's 237234.
Thank you. Before I turn to the authorities, could I just make one point? I was reminded that if one looks at the SCA, you will see the salary at page 274. These are the benefits. And indeed, you will see that they were all heads of claim in this action. So those were the salary benefits and other remuneration elements. The employment package.
Still part of the SCA, is it?
This is still part of the SCA. This is appendix number 2. And there's a similar provision earlier at 273 for Mr. Lemaire. But under the terms of the deal, those were their salary packages going forward. So, could I take you, first of all, to the Muhairi case? This is a case that has quite an unusual history. Dr. Martin Muhairi was the organist of Westminster Abbey, and he was dismissed for gross misconduct. He was employed under a contract with the Dean and Chapter of Westminster Abbey, which certainly I'm sure Sir Jeremy Cooke will know, is a royal peculiar. A royal peculiar means that it is headed by the Queen. It is the Queen's personal church, one of several that she has. And any right of appeal from a dismissal by an officer of the college of Westminster Abbey is to her directly. He appealed that finding, and it was referred by the Queen to the Lord Chancellor, and from him, he appointed as a special commissioner Lord Jauncey. Lord Jauncey was a retired law lord at that stage, so he was in the equivalent of the Supreme Court, and he was appointed a judge to determine this. And indeed, what happened was that the Privy Council was turned into a court. I think probably the only time in its history that that has happened. And there was a trial that took place of that issue, with evidence being given before Lord Jauncey. And I had the honour of representing the Dean and Chapter in that case against an opponent who was then Mr. Patrick Elias, who then became Lord Justice Elias. Could I take you in this decision, which is reported in the Industrial Relations Law Reports for 1999, to page 288. The passage I would like to rely on begins at paragraph 14. The pagination is in the margin. The paragraph numbers are in the margin.
The paragraph relevant is...
Starts at paragraph 14. Now, what I was going to do, if I may, was to invite you to read to yourselves paragraphs 14 to 22, and then perhaps I was going to highlight certain passages. Is that an acceptable course, Your Honours?
How far do you want us to read to?
Paragraph 22. Thank you. Could I highlight the following points? At paragraph 15, you will note that the case that was brought there was not founded on dishonesty, and indeed dishonesty did not have to be made out in order for the case to succeed as it did. Second point, at paragraph 19 that I would highlight, is the passage halfway down, the sentence beginning, or perhaps three-quarters of the way down, the character of the institutional employer, the role played by the employee in that institution, and the degree of trust required of the employee vis-à-vis the employer must all be considered in determining the extent of the duty and the seriousness of any breach. Now, I come back to what was said at paragraph 65A of the judgment, that this employment relationship was no ordinary one. This was an extremely senior employee. He was the chief financial officer of the company. He was charged under clause 9.2 of the SCA with acting in good faith and promoting the business and interests of the company. And within that very agreement, he stood to get a personal benefit provided it was calculated along the lines of the accounting method that was used for the year 2010. Those are all salient factors that one has to bear in mind applying the observations contained in that judgment. And then over at page 21, reference is made to the judgment of Lord Justice Sellers in a Court of Appeal decision by the name of Sinclair and Neighbour. It's by the first hole punch on that page. What was said by the learned Lord Justice was, but whether it is to be described as dishonest conduct or not, I don't think matters. Views might differ. It was sufficient for the employer, if he could in all the circumstances regard what the manager did as being something that was seriously inconsistent, incompatible with his duty as the manager in the business in which he was engaged. And then further, at paragraph 22, again by the lower hole punch, there is a reference to the case of Lewis and Motor World Garages, another Court of Appeal decision, in which Lord Justice Glidewell stated the question as to whether the employer of the conduct of the employer constituted a breach of the implied obligation of trust and confidence of sufficient gravity to justify the employee in leaving the employment could equally imply to a breach by the employee. So what I would draw to your attention is when looking and assessing the conduct through the eyes of the reasonable employer, one has to have regard to the nature of the job that is being done and the seniority of the employee in question and his or her role within the organization. Now, that case, and I stress here that I am bringing this on the basis of the breach of contract and not relying on some additional fiduciary duty as such, which arises with a director where there would be, for example, a duty to account. We're looking here at the contractual obligations. If we look at the Nottingham case, by this stage, my opponent has become a member of the bench. And he was then Mr. Justice Elias, and he made a decision in a case called Nottingham University and Fishel in the year 2000. Reported in 2000 Industrial Relations Law Report at 471. I would just draw your attention to one passage, and starting, if I may, at paragraph 81 of the judgment. And there is an interesting examination by him of the interrelationship between fiduciary obligations and contractual obligations, and when somebody in an employment relationship can be subjected to fiduciary obligations or not. Now, as I say, for the sake of this appeal, I do not need to go into the fiduciary obligations. I rely on the terms of the contract. And in that regard, perhaps I could ask you to read just paragraphs 92 and 93.
And 93.
Please, and 93 in particular, because that's what I want to focus on with you. Now, in paragraph 93, the learned judge there talks about the implied term that is incorporated into every contract of employment as being not to conduct themselves in a manner that is calculated or likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. And he then refers to it as the implied obligation of good faith. And here we have an express obligation of good faith under clause 9.2. And in my submission, this informs the nature of such a term, that an employer and an employee must conduct themselves in such a way that ensures that they are acting in good faith with one another. So, for example, if you have a personal interest that is contrary to the interests of the company, so, for example, in this case, it was submitted before the judge that in trying to convince the accountants to adopt a different accounting practice, which the judge found was the effect, it was a departure from the 2010 accounting practice, which would have, if adopted, have given a personal benefit to Mr. Leese of millions of dollars, was something that was objected to by Mr. Lemaire, acting as CEO of the company. Now, when looking at whether or not that is compliant with clause 9.2, one has to, in my submission, look at the position financial officer, the fact that he was in the higher echelons of the company, and he was in a position to influence the accountants as he sought to do. And all of that conduct, in my submission, goes to the very heart of that clause, the good faith clause of 9.2, which I submitted did not receive attention expressly in the judgment itself.
At the time of his termination,
it is. So can I now turn, please, to the events that led to the termination on the 11th of February? Now, it was the defence case below that Mr. Leese attempted to inflate those accounts for the final accounting year by using a novel method of accounting different to that used in the 2010 accounts in a way that would have benefited him personally to the tune of around $5 million. If you look at the judgment, please. At page, it's page 56 of the bundle. It's paragraph 13, I think. Yes, 13, and it's paragraph number 42.
You say page 51 in bundle A?
It's 56 of the bundle, but internal pagination, Your Honour, it's page 13 of the judgment.
Yeah.
Now, paragraph 42, he summarises the nature of the defendant's case. And makes a finding, and it's the first sentence that I'd take you to, at paragraph 48. At page 17, he says, I accept the defendant's expert's conclusion, which made the observation that if the claimant's proposal was successful, it would go against the previous year's accounting methods and inflate the defendant's revenues in the 2013 financial year. Now, the corollary of that is that the retained earnings go up correspondingly, and it was $5.2 million, and that is the sum to which Mr. Leese's entitlement would have been increased. I come to the second sentence of that in due course, but before I do so, the point that was being made in paragraph 42 is that communications were being sent by Mr. Leese to the company's auditors, PwC, and that is referred to at paragraph 45 of the judgment. There are two documents in particular that were not copied to Mr. Lemaire. At 45B, there is reference to a spreadsheet of revenues in which the claimant provided the data requested and highlighted what he believed to be the effect on revenues if revenue from postponed launches remained unrecognized without actually adding those postponed revenues to the equation or final revenue figures. That document is at A16, A tab 16. And you will see it was sent only to PwC. All the email addresses, beginning at page 293, nobody in the company received that. Then, on the 29th of January, the following day, he provided PwC, copying the accountants within the company, but not Mr. Lemaire, a recalculated figure in respect of the unrecognized revenue relating to commissions from planned launches amounting to 5.2 million. At page 57, internal page 14, paragraph 45, letter C. Judgment, Your Honour.
Internal pagination is...
Internal pagination 14, Your Honour. It's letter C. So those communications that were sent were not communicated to Mr. Lemaire. Now, it raises the question, what was Mr. Leese doing asking for this accounting method to be adopted? Because by this stage, it had been agreed between the parties that he was due to leave on the 15th of February of 2014. So these were his final days within the company. And here he is, writing to the auditors at a time when he is bound by the SCA to adopt the same accounting method, inviting them to consider including these revenues, which would not have been done under the old accounting revenues, the effect of which, if adopted, would have been to give him personally $5.2 million by way of returned earnings under the SCA. Now, the pleaded allegations against him are set out in the judgment at page 9 and 10, paragraphs 23 and 24. And you'll see they are attempting to inflate the accounts by 5.2 million, taking company property, contacting the company's customers, and at 24, described as minor reasons for termination, refusing to leave the room when he was asked to do so during the meeting with PwC on the 11th of February 2014, self-proclaiming to staff that he had been fired when he hadn't, refusing to allow Mr. Lemaire to see the contents of a box of items that he took from the defendant. You will no doubt be aware from the skeletons, they included the laptop containing the confidential data, informing Mr. Lemaire that he would send an email to all of the defendant's clients regarding his exit from the company. So those were the catalogue of complaints that were made that justified, say, the defendant, the invocation of Article 57A. Now, the events of the 11th of February of 2014 are of great significance when determining the answer whether or not Article 59.2 was rightly invoked. And somewhat surprisingly, the judge makes very few findings on what actually happened that day. If you look at the judgment, first of all, there is a reference to the 11th of February at paragraph 14. Now, that is the extent, in essence, of his addressing the 11th of February until one gets on to paragraph 88. Which is at page 26 of the internal pagination. Where there is, under the heading, other reasons for termination. And he recites at 88 the allegations and says in 89, in a blanket form, the claimant denies the defendant's allegations. And in fact, if one looks at the pleadings, that is not strictly correct.
Paragraph 88.
Paragraph 88 is the defendant's allegations. At paragraph 89, the judge says the claimant, on the other hand, denies the defendant's allegations and submits that they cannot stand as cause to terminate his employment. Then there is a discussion and a conclusion at 94, where the judge opines on whether the other reasons, simpliciter, would justify termination for cause. Now, as I say, the narrative of what happened on the 11th of February is essentially confined to paragraph 14 of the judgment. And in my submission, it is incomplete. There was certain of the factual matters set out in the respective statements that was common ground, and some of it was not. But if I could take you, please, in volume A to tab 21. This is the witness statement of Mr. Lemaire. And between paragraphs 64 through to 75, at page 329, he sets out a detailed narrative of what occurred. And there is one passage in particular that I invite you to look at and have regard to, and that is paragraph 67. Because at paragraph 66, he says, this is Mr. Lemaire, I decided that I needed to discuss this. This was the attempt to put all this income into the 2013 years, and asked everyone to leave the room. Under protest, Mr. Lease leaves. We called, he says at 67, we called Mr. Lease back into the room to get his views on each item on the agenda. I considered that it was for Lease and PwC to go through the issues and reach agreement on the correct approach to take. Now, the judge does not refer to that in the narrative at paragraph 14. And as one of the 4 reasons for declining to uphold the removal of the computer with the confidential data at paragraph 65 of the judgment, internal page 21, at page 22, one of the reasons that he distinguishes the English line and approach of authority is set out at 65D, where he says, following the meeting of the 11th of February 2014, Mr. Lemaire had not at any stage sought to afford the claimant an opportunity to comment on the correspondence with PwC. Paragraph 65D, page 22 of the internal pagination. 65D, page 22 of the internal pagination of the judgment. I beg your pardon. I had taken you from paragraph 67 of his witness statement. I now invite you, bearing in mind what was said there, to return to the judgment.
And
at page 22, this is a continuation of paragraph 65, Your Honour. Now, this is important.
I see, okay.
Because it is one of the grounds that is relied upon by the judge for saying that no just cause was established. Now, the way that my learned friend seeks to do this, to deal with this point, is to say in his skeleton, which is in volume D, tab 4, paragraph 25, what he says
want us to look at it? B or D?
I'll read it to you. I'll read it to you. It'll be easier. It's a very short passage. It says that this is an impermissible attempt to seek to go behind the judge's findings of fact. It is clear that the judge rejected Mr. Lemaire's evidence, and in any event, the appellant selectively focuses on the first sentence of 65D. Well, I make no apologies for focusing on that sentence because it is wrong. It is unfair that it doesn't reproduce the allegation. He doesn't address it. He doesn't make a finding on it. It's not reproduced at paragraph 14 when setting out the defendant's case. And I hazard to guess that perhaps if one doesn't deliver a judgment until nearly 12 months after the date, the full facts fade from your memory. But that was clearly part and parcel of the case, and the narrative that appears in those 11 paragraphs from 64 to 75 of Mr. Lemaire's statement is a detailed account of the defence case, and it had to be considered. It had to be considered properly and ruled upon.
What did Mr. List say about that?
He denied it. He said that he wasn't given the opportunity, but the allegation made by the defendant is not even produced, not considered. The allegation contained in paragraph 67, the evidence from Mr. Lemaire that Mr. Leese was invited back into the meeting to deal with the points that he there identifies. Now, the judge doesn't produce that. As I say, this very important sequence of events of what happened that day is not the subject. I mean, one would expect in a judgment that the factual narrative would be set out and the parties' respective submissions reproduced and findings of fact made on which the judgment is then based. And as I say, the absence of an opportunity to explain is expressly put forward as one of the reasons for departing from the approach of the court in Brandon.
Not immediately apparent that paragraph 67 and the judgment are contradictory of each other. What the judge says in 65D is that following the meeting of 11th of February, Mayor had not at any stage sought to afford the claimant with an opportunity to comment on his correspondence with PwC. So in terms of time, in terms of subject matter, that's different from what happened at paragraph 67 of Mr. Lemaire's witness statement.
With respect, with respect, that's not correct. If you look at 65 of the witness statement at page 326, what was being considered at the meeting were the communications with PwC that had been made. The case of Mr. Leese was that he left the room and didn't come back. The case of Mr. Lemaire at paragraph 67 was that the very thing that was the subject of discussion, which was the very communications with PwC, and the way in which these figures were sought to be inflated and how and when they were done, was the subject of discussion. And in my respectful submission, it is incumbent on a trial judge to address that in his judgment and deal with it. And I do not accept, on a fair reading of paragraph 65D of the judgment, he addresses it, and it is significantly so because when reproducing the defendant's case in paragraph 14, it receives no reference. No, I'm told the auditors did not give evidence at the hearing. So if one moves on to the judgment at page 69, internal pagination 26, the way in which the judge deals with the other allegations, as he calls them, other reasons for termination, is at paragraph 94, where he says, in my view, none of the reasons provided by the defendant in paragraph 88 of this judgment amount to gross misconduct qualifying as cause for a reasonable employer to terminate an employee just 4 days before the employee's scheduled last day of employment. So he doesn't find that they're not made out. He finds that by themselves, looking at paragraph 88, that doesn't amount to just cause. So there are effectively 3 elements that he considers. One, the activity relating to increasing the accounts by 5.2 million. And what he says in his conclusion at 48 is that it is correct that this would have gone against the previous accounting methods. It would have inflated the revenues, but the way in which he posed the questions to the accountants, the auditors and managements did not reach the threshold of gross misconduct and transparency in the claimant's approach, that he acted in good faith.
Reading from paragraph
48. That's internal paragraph 17. And I'll come to the second sentence in a minute. But that's how he deals with 48. On the company property, he addresses that separately at paragraph 65.
Reading from the judgment?
I'm reading from the judgment, Your Honour. So I've just taken you to 48, which is the question of the inflation of the accounts. At paragraph 65, in fact, can I read 64 and 65 together? He says, at 64, as mentioned above, the claimant's retention of company property, the laptop, and data is serious and may ordinarily justify instant termination by his employer. However, after a careful analysis of the facts of this particular case, I am inclined to accept the claimant's submissions that his conduct was not so serious as to warrant his immediate termination on the basis that the employer could no longer continue to work with the employee. Now, he does so on the basis of 4 matters, which are itemized at paragraph 65. And as I say, I've already addressed you on item D, which in my submission was unfounded because it did not entail a proper consideration of the defendant's case. But the point I make generally, which I will return to, is segmenting these and looking at each of them in turn is not the correct approach. Termination for cause can consider a number of aspects of a person's conduct over a period of time, certainly within the course of 1 or 2 days. And the idea that you take each one in turn and say, well, would this justify a termination for cause? No. Does that justify a termination for cause? No. What about that? Rather than looking at the totality of the conduct is a completely unacceptable, in my submission, and artificial way of addressing it. And I will take you to the authorities on this. But further on in the judgment, the judge went on at paragraphs 96 and 97 to say the claimant's behaviour might not be what the defendant was expecting. But it is in no way, in my opinion, actions that strike at the heart of the employment relationship. Now, I stress the words, in my opinion. because he seems to be substituting his own judgment for that of the employer, something which one counsels against. And that, too, is borne out to a degree in the earlier passage that I've taken you to, at 64, where he says, I'm inclined to accept the claimant's submissions that the conduct was not so serious. So he invokes this test. In my opinion, these actions do not strike at the heart of the employment relationship. And he repeats,
Where are you now?
I'm reading from 96. And
On to 97, okay.
And then 97, he says, thus, the above-mentioned reasoning and discussion takes us to the conclusion that the defendant has failed to satisfy this court, that as a reasonable employer, immediate termination of the employment relationship was warranted due to the employee's misconduct, which must be so serious as to strike at the heart of the employment relationship such that the employer can no longer continue to work with the employee. Now, it is our submission that this propounds the wrong test. It is not what is in the statute. Statute, you will find in Volume A, beg your pardon, it's in Volume C.
One.
It's in, yes, C1. I'm afraid there's only one volume C, so I will be calling it Volume C, and that's at tab 6. At 59A, termination for cause. This says, an employer or an employee may terminate an employee's employment for cause in circumstances where the conduct of one party warrants termination and where a reasonable employer or employee would have terminated the employment. So basically, what this does is propounds a test. Does the conduct warrant termination? Would a reasonable employer have terminated? And it is instructive to look at a case which my learned friend places a great deal of reliance on, which is a case called Adil and Frontline, which you will be familiar with, or certainly two members of the court will be familiar. That is in Volume D of the authorities bundle, or D1, I think it's numbered in yours. And at this stage, I just want to take you to one paragraph. What happened in this case, I'm sure you will be more familiar than I was, until I studied in some detail. Article 59A, does you want to have it?
Which tab, please?
It's in Volume D at tab 15. And if I could take you initially to the summary of the judgment, which is at page 1630. And if I could take you to the paragraph in the middle of the page, 1631, with the sentence beginning, Justice Giles observed. Do your honours have that? Justice Giles observed, at least at trial, it had been common ground that the claimant's employment was orally terminated on the 30th of June 2013. Moreover, if the defendant argued that it had exercised the contractual right to terminate without notice, but with payment in lieu of the notice period, it could not then justify the termination as the exercise at the time of the right to dismiss for cause. The exercise of the contractual right created rights and obligations, specifically the debt of payment in lieu of the notice period, which cannot be retrospectively undone by later showing a different basis for termination. I emphasize the next sentence. The claimant's objection to the defendant's purported reliance in its closing submissions on Article 59A of the DIFC employment law as a source of its ability to terminate the employment for cause was upheld as it had not been pleaded and the counterclaim had not been defended on the basis that the claimant's conduct had warranted termination for cause pursuant to that article. Now, it was not open to the defendant to rely on acts or omissions after termination. I needn't trouble you with that because we are not seeking to challenge that particular finding. So that is the passage in the head note I would like to take you to. Can I take you in the body of the judgment to paragraph 201 at page 1682? Paragraph 201, do your honours have it, says, after the first sentence, the concept of conduct warranting termination in the article, that is Article 59A, appeals to a standard other than breach of contract or fiduciary duty, one which may possibly be wider than either, but in any event can involve a different investigation. So Justice Giles in that case refused to permit the argument to be run because it was a matter that had been raised only at the end of the case and therefore could not be relied upon for a variety of reasons, one of which was it would have entailed a different exercise. So the first complaint that we make is that the judge applied the wrong test, a more onerous test, when he concluded that a reasonable employer would not have terminated for cause. If you could look, please, at our supplemental skeleton, which is loose, which you will not have had a chance to read yet. It's not a tab. I think it's a loose document. It's the one that I think Sir Jeremy said was loose on the desk. Supplemental skeleton of the appellant.
Of the appellant, yeah. Okay.
Thank you very much. If you look, please, at paragraph 10, which is internal numbered page 5. If I could take it up from paragraph B on page 6. Restricting the scope of the test by the application of a new threshold, i.e., if it does not strike at the heart of the employment relationship, a reasonable employer would not have terminated. Such an approach is inconsistent with Justice Giles' dicta in Adil and Frontline.
Paragraph number?
I'm reading at page 6. It's a continuation of paragraph 10, letter B. And also paragraph 11. The gloss on 59A is unnecessary and impermissible in my submission.
Does it really add anything?
Well,
Can I finish the question?
of course.
context of the passages that you've directed from discussion about phraseology, which is undoubtedly different.
In my submission, it is an unnecessary gloss, and if you look at the conjunction of those words with the preface, in my opinion, in the paragraph that I earlier took
That's
you
a separate point, the in my opinion point, because you say he's substituting his
Own
view
judgment.
for that of the reasonable employer. But let's just focus on the striking at the heart of the employment
In my
relationship.
submission, it is a more onerous test, because one could envisage that there would be circumstances where there would be breaches that might not go to the heart of the relationship, but would still nonetheless be regarded as serious. For example, my understanding, looking at the case of Ithar and the judgment of Sir Anthony Coleman, there is a difference in DIFC contract law between a condition under English law, breach of which would justify bringing a contract to an end, that imposes a rather different standard. What we have here is not a requirement of a repudiatory breach or a fundamental breach or a breach of a condition understood in English terms. It is simply, was in the circumstances the termination warranted for cause, and would a reasonable employer in those circumstances have terminated for cause? As was said by Justice Giles, that is a different, broader, non-contractual investigation, and can take account. I mean, if you like, it's more like, you're probably more familiar with the just and equitable principle for unfair dismissal. So one is looking under English law at whether something is a fair dismissal as to whether it was just and equitable in all the circumstances. And that doesn't import necessarily contractual considerations. So in saying that it's got to strike at the heart of the employment relationship, it's focusing on the wrong test. The test is there and it's clear. It doesn't require modification. And in my submission, what the judge was doing there was in fact imposing a higher standard. And there are a number of factors that appear. One is the substitution of his opinion. Two, there is this strike at the heart test. And three, there is the 4 days until the termination of the employment in any event point, which I will come to. So in response to your question, Your Honour, I would suggest that this wording does elevate it and subject it to a higher standard, that there is a clear test that has been propounded in the frontline test, which identifies that the investigation is somewhat different. I mean, I accept that it is difficult to conceive of a situation where an employment relationship which has conduct which strikes at its very heart isn't warranted. But I can see equally that the other side of the coin is not necessarily the same. And I can see that you could have conduct that doesn't strike at the heart of the employment relationship, which is nonetheless warranted.
By what criteria would you apply that? Because it's just a verbal formula. If you have no clarificatory explanation of how that test is to be applied, or no ability to rely on case law from common law countries to guide you in that, then it's just going to be, palm tree justice, isn't it?
Well, with respect, my Lord, no. Courts in this jurisdiction and abroad are asked to make objective decisions looking at the facts all the time. For example, in negligence cases, you have to ask yourself whether a professional conducted themselves...
So still attacking the in my opinion?
No, I'm not. What I'm saying, you're saying if you don't have clarificatory words, is the court put into impossible situations where it will effectively be carrying out palm tree justice? That was the question that was put to me.
Yes.
The answer I give you to that question is no, it is not an invitation to embark on palm tree justice. It is embarking on a question that presents itself to courts in this jurisdiction, others, across the board. We are often asking courts to form objective views as to whether conduct is reasonable. That is not the same as asking whether the test has this gone to the heart of the relationship. Those are not synonymous. And I can identify every case that strikes at the heart of the relationship will be a termination for cause. But every termination for cause, in my submission, is not necessarily one that has to go to the heart of the relationship. And that is the difference. As Justice Giles says, it is an exercise that is envisaging a wider, different investigation. It's not just plain and simple fundamental breach. Of course you can get guidance from the authorities. I'm not saying that you can't. But what I'm saying is they are not a substitution for the words of your own article. And those words make it clear that you have to satisfy 3 tests, and this is the Macduff test. Is it conduct that warrants termination? A reasonable employer would have terminated in those circumstances, and that reasonable employer is attributed with the attributes of the employer himself. So, for example, if the employer in the past had acquiesced or waived particular items that are now relied upon, that can be held against him because a reasonable party in his shoes would not have done the same. That's the test. Now, there's no need to add to it by reference to words that strike at the heart. Could we look at Macduff? It's at volume C1, tab 19.
Before you go there, can we just pick up the exact terminology that the judge uses?
Yes, of course.
Ones that I picked out were paragraph 61, first of all, where that up in ordinary circumstances. Would be very serious misconduct as it goes to the heart of an employment relationship. One of the judgment.
Yes, I'm there.
Then paragraph 64, inclined to accept the claimant's submission's conduct on the basis that the employer could no longer continue to work.
Yes. Yes.
Then again at 66, find the claimant's conduct was not serious enough to go to the heart of the employment relationship, on the basis that the employer could no longer. Days.
Yes.
So that 2 tests there, both tests, but conflated and conjoined with the 4-day point.
As is the case at 96.
And then I was sort of going on to 96 and 97. And I think, as far as I've been able to see, those are the paragraphs that encapsulate criteria the judge was applying.
I agree.
So 96, in my opinion, strikes at the heart of the employment relationship. 97, again, the 2 elements must be part of the employment relationship, such that the employer can no longer.
Those are the variety.
Is there anywhere else that he identifies the test that he's applying?
I think the Lordship has been pretty comprehensive.
All I could find, but
I mean, at paragraph 20, he refers to it as a central issue being unfair dismissal.
Taking us to KBH and Macduff.
I'm very sorry, Your Honour, I didn't hear you.
But we interrupted you. You were taking us to Macduff and KBH.
Yes.
And, now we are there, so please tell us.
Yes. So, in Macduff, this is at... Bear with me, please. C tab 19. And if you could look, please, at page 1487. Now, he's dealing here with the predecessor to Article 59A, which was then Article 60 sub 4, but it's the same language. If you look at paragraph 22, you'll see that the learned judge there stated, and this again is Mr. Justice Giles sitting in the Court of Appeal, expresses the cumulative requirements. First, that the employee's conduct warrants termination, and second, that a reasonable employer would have terminated the employee. The second is in strong terms, that a reasonable employer would have terminated. It is not enough that a reasonable employer could have terminated the employee. Ordinarily, if an employee's conduct warrants termination, it would be reasonable for the employer to terminate the employee. Something more must be involved in deciding whether a reasonable employer would have terminated the employee. And then he says the construct of a reasonable employer must be given context. Thus, for example, at the end of that paragraph, if the actual employer has known of the relevant conduct for some time and done nothing, it should be asked whether a reasonable employer who had known of the relevant conduct for some time and had done nothing would have terminated the employment. And then at paragraph 24, he goes on to consider the range of reasonable responses of a reasonable employer and says, well, that's not the same thing as would a reasonable employer have terminated. And he says the test stems from legislation, this is the foot of 24, in quite different terms, applying the concept of fairness fleshed out by whether the employer acted reasonably or unreasonably in treating the reason for dismissal as sufficient reasons. And this, again, it was the same trial judge as in this case. He says at 25, despite looseness of expression, on a proper understanding of the trial judge's reasons, I don't think he misdirected himself. Because what he then went to do was to say, well, I didn't find that the reasons given in the letter were the real reasons. So what were the real reasons? See paragraph 27. And he says it was natural to embark on that procedure. Now, here, I accept the test that is set out at paragraph 22 and 23, that you've got to ask, does the conduct warrant termination? Would a reasonable employer have terminated? And indeed you do attribute to this hypothetical reasonable employer the same background as the actual employer. And I can see an argument that the band of reasonable responses may produce, on rare occasions, a different outcome. But I have to say, in practice, it does seem to me a bit of a distinction without a difference. So, for example, you ask yourself as a judge, was the employer warranted in terminating? Answer, yes. Step 2, would a reasonable employer in the same circumstance have terminated? Now, it seems to me that when you're doing that, you can't impose your own judgment. You can't ask yourself, in my opinion, would I have done that? That is time and again said to be the wrong test, because that's not applying the objective reasonable employer. And that's clear from Macduff, and that exactly mirrors the approach of the English employment tribunal system, which I will take you to.
Just putting himself in the place of the person on the man on the Dubai omnibus.
Well, he is not the man on the Dubai omnibus. The judge is not the man on the Dubai omnibus.
Yes.
No, he's not. No, he's not, with respect. And that is what the English authorities have said time again. You do not substitute your own opinion. You have to embark on a more sophisticated exercise and ask, would a reasonable employer have reached this conclusion in the circumstances of this? Not, I wouldn't have behaved like this. That's not the test. And the occasions where that has happened, the appeals have been allowed, and in my submission, correctly so, because it's not a subjective test. Applying the reasonable employer test. And that doesn't entail conduct that strikes at the heart. It doesn't have to be conduct so severe that no one can be expected to work together. It can be such that it doesn't warrant the continuation. I can see situations guided by the authorities where serious breaches of conduct will satisfy that test. But that's the point. Muhairi, see Justice Giles, paragraph 201, frontline authority. One that permits not just strict contractual consideration. Now, can I go back, therefore, to this subjective view? We, in our skeleton, our main skeleton, which is in Volume A, Tab 3, at paragraph 15, sorry, paragraph 16, page 15. Paragraph 16, page 15. Apologise for the confusion. This is of our skeleton. This is in Volume A, Tab 3.
A supplemental skeleton.
No, our actual first skeleton.
28th of July.
Correct.
Paragraph?
Paragraph 16, where we talk about the judge substituting his own for Elseco's. And we refer in paragraph 17 to two authorities, both in the Court of Appeal. First were the joined appeals of Foley and the Post Office and Midland Bank and Madden, which is in volume C at tab 12.
On criticizing the judge's methodology, but you don't actually, I can't find your actual substantive case as to why you say your clients were justified in terminating applying the test in.
But we set that out with clarity, with respect, in the skeleton.
Yes, please show me then.
Yes, of course. If you read, please, paragraphs 23 and 24
Document
of our skeleton, and 25, and 26. And the judge summarizes those matters in paragraphs 24 and 25 of his judgment. Sorry, 23 and 24 of his judgment.
Let's not distract from going back to the judgment again.
I'm not distracting. You're asking me a question.
I'm trying to get you to help you develop your case for my benefit or our benefit. I'm just saying, just show me where in your skeleton you tell us this is why we were justified in sacking him.
Right, it's the paragraphs A, B, and C of paragraph 24, developed in paragraph 25. There were several elements of Mr. Lee's conduct which were relevant to his dismissal, including Mr. Lee's attempt to inflate the 2013 account, and the judge's passage from paragraph 48 is recited. Mr. Lee's behaviour on the 11th of February 2014, during meetings, announcing to the office he'd been fired when that was untrue. Contrary to Mr. Lemaire's objections, taking property belonging to Elseco without permission. Mr. Lee's threats to Elseco that he would contact Elseco's clients without Mr. Lemaire's agreement. Well established that where there are a number of reasons for dismissing an employer, and all of those reasons are based on the employer's conduct, as in the case of Mr. Lees, then all elements of the appropriate to rely on a principal act of misconduct. That is how we put the case. You've got component parts of the conduct that is complained of in the round, taking them as a whole, because the just cause isn't each individual sum of its parts. And that
It'd
is
be good if you could show us this case, which seems to be your main proposition, which is GM packaging.
Of course,
or were you going to
let's
do
it.
that later?
Absolutely. I'm very happy to take you to that now. It's at tab 18.
Authorities bundle.
It's in volume C, C1, tab 18. Okay, this is a decision of the Employment Appeal Tribunal.
Found the case. You want to give me the page?
Right, if you look at the summary, you'll see the middle paragraph at 1467 states, this is looking for the reason or principal reason for the dismissal, which has to be established under the English legislation. And there are a variety of different reasons set out in the statute. The reason or principal reason for dismissal relates to the categories of potentially fair reasons within Section 98 of the Employment Rights Act 1996. Where the question is solely conduct, all constituent parts of that reason are relevant to the reasonableness question under Section 98(4) and not the principal act of misconduct. That is considered in the judgment at 1472. And you will see that at paragraph 21, they considered that the principal reason for the dismissal, in GM's mind, was sexual activity between the claimants on the company premises. They went on to find that the dismissal for that reason could not be characterized as gross misconduct, and the reason fell outside the band of reasonable responses. There was then an appeal. And at paragraph 25, 1473, they say that in our judgment, the Employment Tribunal fell into error in two respects. The first one was procedural. I pass over it. The second begins at paragraph 26. The use of the term principal reason by Mr. Tinian in relation to the sexual activity adopted by the Employment Tribunal represents a fundamentally erroneous approach to Section 98. Section 98 requires the employer to show the reason, or if more than one, the principal reason for the dismissal. The reason is one of those falling within subsection 2 or some other substantial reason. The list of potentially fair reasons in subsection 2 includes conduct, capability, redundancy, etc. Thus, if the set of facts or belief to adopt the Abernethy formulation includes both conduct and capability, the question is, which is the principal one? Provided it is a potentially fair reason under subsection 2, the reasonableness question under section 98(4) arises for determination. Here, the only reason for dismissal related to SH's conduct. That included all the matters taken into account by DP on dismissal. The point that is there made is that you have to look, when looking at conduct, at the entirety of the conduct. It has several component parts. And the fact you don't divide it up into principal, secondary reasons. There are reasons that were relied upon that cumulatively amount to conduct. And that was what caused the employer to terminate, he says, under Article 59A. And I rely upon that to say that it is an artificial exercise to test each individual item by the yardstick of just cause. You have got to look at the entirety in order to do justice to the points that are being advanced. They are not looked at in isolation, they are looked at in the round. And the learned judge considered first the accounting issue, then the computer issue, and then the other matters. And he reached different conclusions, taking them each independently. And part of the reason for that, in my respectful submission, and I invite you to look at the narrative in the witness statement of Mr. Lemaire, is that he pays scarce attention to the events of the day in his descriptions in the judgment. The defence case is summarised, as I pointed out to you, at paragraph 14. So I turn to the next complaint. Oh, sorry, I didn't take you to the authorities on not substituting your own judgment for that of the reasonable man. Could I take you to two authorities quickly on that in volume C? The first is at C12. That's a sanction there. Could I take you to paragraph 53? This is the Court of Appeal in this case.
(1355).
1355, exactly so, Your Honour. And that was approved in a later Court of Appeal case at tab 13, which is Sainsbury's Supermarkets and HIT, where the appeal was allowed on exactly that ground. See paragraph 18.
Right. What are you pointing out from this 1355?
1355 says that you should not substitute your own judgment for that of the employer.
Yes.
And that was approved and applied, resulting in an appeal being allowed in that case, in the case of Sainsbury's Supermarket and HIT, beginning at 1368. And it's paragraphs 17 and 18. Where the passage I think I've just taken you to was referred to and relied upon, and the conclusion at 1371
We jump from 1368 to 1371?
Yes, because basically those are the two passages in the judgment that are referred to in the earlier case, and it is applied in the conclusion at paragraph 28. He says that the learned judge there, who was delivering the Court of Appeal judgment, which was Lord Justice Muhairi, with which both Lord Justice Jonathan Parker and Lord Justice Ward agreed. Lord Justice Muhairi is the former president of the Employment Appeal Tribunal and then elevated to the Court of Appeal. He said, I'm unable to agree either with the decision of the majority of the Employment Tribunal or with the decision of the Employment Appeal Tribunal. There is no doubt that the appeal from the Employment Tribunal raises a question of law. That question is whether the Employment Tribunal applied the correct legal test to decide whether Mr. Hitt was unfairly dismissed for a conduct reason. The test applied by the majority in the Employment Tribunal, and I also think by the dissenting chairman, was that laid down by the Employment Tribunal in Madden. Applying that test, the majority considered that the investigation was not reasonable. They arrived at that conclusion by substituting their own opinion as to what was a reasonable and adequate investigation, instead of applying, as was required by the Court of Appeal in the subsequent decision, reversing the EAT decision in Madden, the objective standard of the reasonable employer as to what was a reasonable investigation. So in that case, there was a clear distinction that was drawn, and it resulted in the overturning of the decision.
All of these cases you're citing, the English cases, unfair dismissal.
They are on unfair dismissal, but they are all concerned with standards of a reasonable employer. And the standard of the reasonable employer is imported directly here in Article 59A.
Standard is not, it's not the same criteria that they adopt.
The standard of a reasonable employer is absolutely the criterion.
So the criteria is whether a reasonable employer would have sacked the guy.
Yeah. No, the test is still by reference to a reasonable employer.
That's the benchmark, the measurement ratio factor. What I'm saying is that the actual criterion for dismissal is different in our legislation.
But it's not. If one looks...
Fairness doesn't appear.
Sorry?
The word fairness doesn't appear.
No, but...
in section Article 16.
No, the words for cause appear, but for cause is determined by reference to the test of a reasonable employer.
That is the way in which you do it, but what you have to determine is not the same as what you have to determine in England.
Well, I agree, because the test in England was the decision that was taken for a permissible reason and one that was just and equitable, which has been defined as being within the band of reasonable responses of a reasonable employer. Here, what you're being asked to do is to ask, was a termination for cause warranted? 2, would a reasonable employer have terminated? That is an objective test. It is not, in my opinion, this employment have been terminated? You don't substitute your own opinion, as they did in the EAT, in the Hit Sainsbury's case.
Only uses that phrase once, am I right?
Say again?
The judge only used that phrase once?
Which phrase?
My opinion.
I think he uses it twice.
Let's just have another look at it, please.
But can I say, once is enough for the purposes of my submission. If he's got it wrong once, then it undermines the value of the judgment. He says at 96, in my opinion, actions that strike at the heart of an employment relationship, which was all ready to come to an end in 4 days.
Okay.
And then there's an earlier finding, I think. 1 second.
So.
Yes, in my opinion, paragraph 44. And also at 169, I'm told, there is a reference.
Yep, paragraph 44, did you say?
169, it relates to Article 18.1, and therefore it's not on point.
The essential difference between Article 59, you're looking at a yes or no answer. Objective view, what would a reasonable employer do? In the English line of cases, is that within the range of a reasonable employer might have done? And if it is, okay.
But in each case it's objective.
Yes, so you're looking at it and saying, well, there's a range of possible reactions, and if it's within the range, then it's justifiable. But under Article 59, you have to look and say, would a reasonable employer have done this? Yes or no? And so
Correct.
it's a slightly tighter test.
It is a tighter test, and that was acknowledged by Justice Giles in the Macduff case. And I don't quibble with that. It is a tougher test that has to be satisfied. It's not within the range of reasonable responses. It's would this hypothetical reasonable employer, armed with the conduct that this employer has, for example, for acquiescence or waiver that doesn't arise here, but you have to import those characteristics into the hypothetical reasonable employer. But it is still the reasonable employer and not you. That's the point I make.
I have the third reference, please.
I beg your pardon?
I thought your colleagues told you that there was yet another reference to, in my opinion.
It was, but it's at paragraph 169 that relates to Article 18.2 and is therefore not on point.
Right.
So, just to conclude, we submit that in this case, had the judge applied the correct test and looked at the conduct complained of as a whole, instead of artificially segmenting the matters, he should have reached the conclusion that the test for cause was clearly established under Article 59A. Now, the second complaint that we made is the way in which the judge sought to distinguish the Brando case at paragraph 65. And I can take this quite quickly because I've already addressed you on one of the 4 reasons. In that case, the Brando case, if I could take you please to C14.
Sorry,
C14, which is the decision of Mr. Justice Jack in Brando Advisors UK Limited and others against
no wonder
Chadwick.
he misled. He felt it differently in his judgment. Okay.
Now, in that case, an employee removed confidential information belonging to the employer for her own purposes for use in any dispute with her employer or regulators that might arise. If you look, please, at paragraph 18 of the judgment, at 1381, the judge says at the foot of that page, I accept, without question, that she did not intend to use the material for a nefarious purpose. That allegation has not been made. I think her purpose was to arm herself for the future in any disputes with Brando or with the regulators which might arise. And then at 21, foot of the page, the first point to be made here is that Miss Chadwick simply emailed to herself a vast quantity of material stored in certain files on her company computer, regardless of whether its content might be relevant to any dispute with Brando or any problem between Brando and a regulator. Her explanation is she had no time to be particular. And then the material paragraphs are at 23 and 24. Considers 2 earlier cases and says, in my judgment, the 2 cases relied upon fall a long way short of establishing that Miss Chadwick was entitled to act as she did. I shouldn't get drawn into any wide statements of principle which are unnecessary to my decision. I am doubtful if the possibility of litigation with an employer could ever justify an employee in transferring or copying specific confidential documents for his own retention which might be relevant to such a dispute. If such a dispute arises in the ordinary course, the employer must rely on the court's disclosure processes to provide the relevant documents. Even if the employee is distrustful whether the employee will willingly meet its disclosure obligations, he must rely on the court to ensure that the employer does. But on any view here, there can be no justification for the exercise which Miss Chadwick carried out here. and therefore he concludes that she was not entitled to do what she did and her conduct was in breach of contract. That was confirmed, that approach, by recently in two decisions. If you look, please, at C20, this was a decision of last year by Mrs. Justice Whipple, the case of Farnham and Sutherland Association Football Club. The passage begins under the heading wrongful dismissal claim at page 1506. And at 73, the learned judge finds, second line, over the course of his employment, Mr. Farnham banked the defendant's documents and emails at home. This became a particularly pronounced practice after the 3rd of April 2013, when he feared that his employment would be terminated by SAFC. And then at paragraph 79, applying Brando and a subsequent authority by Mr. Justice Coulson, this is at paragraph 77, the learned judge held at 79, Mr. Farnham had no authorization from the board to build up a private bank of confidential information at home or on his or his wife's personal email account. Doing so was a breach of the SA. In my agreement, this was a serious breach. So that is the approach that is taken. Bearing that in mind, can we now go to the judgment, which is at paragraph 61 of the judgment itself. This is the finding that in normal circumstances summary termination would be warranted. And then he applies the reasonableness, and at 63 says the reasonableness test would require the court to take into account all the circumstances and factors surrounding the employer's conduct and the employer's reaction at the time of the termination in order to answer the question of what a reasonable employer would do. Now, I don't take issue with that. What I take issue with is the way he then embarks on the exercise. So I accept that when you're looking at this reasonableness test, of course you look at all the facts and circumstances. Indeed, my complaint is that he didn't. My complaint is that he substituted his own view. And my complaint is that he put a test that was too high. Now, of the three remaining matters at 65, first, he says that the employment relationship in this case is not an ordinary one, and that he had a special interest in the company's final accounting year.
That is the paragraph?
Paragraph 65A. So that's the first reason that the judge gives for departing from Brando. And it is my submission that far from being a reason to depart from Brando, a fortiori it should be applied. This was a man who had been trying to get this 5.2 million figure included into the account in a way that would have given him the benefit of a personal payment, and that he had no right to remove that confidential data for his own purposes. He took it away with him. He took the computer
away with him.
Yeah, containing the company's confidential data and information, and when asked to return it, refused to do so, and when he did return it, in March, all the data had been wiped, and the hard drive.
At the time that he downloaded all the information, still a director of the
Yes,
company.
he was, but he took that computer, not for company business, but his explanation was he wanted to keep it just in case. And then what happened was he was asked to return it, and he destroyed all the information.
When was he asked to return it?
He was asked on several occasions. The first of which I think...
No. Let's just take the cut-off date.
Second, please.
All I want to know is whether he was asked before or after he was terminated.
Right. What happened was he was leaving the office with a box and the computer on the top of it.
That's the passage you read out to us from Mr.
He was
Lemaitre.
stopped by, and it's not challenged. This is common ground. He was challenged by Mr. Lemaire, and he said, Mr. Lemaire asked me some questions, and I was not prepared to answer them. Mr. Lemaire said, I asked to see the contents of the box, and he refused to let me. So
This
those
is
are
when
the
he was
rival
still
accounts.
an employee and a director, and the CFO.
Yes, and his reasons, he said, that he advanced that was because he wanted to keep them, not for the company business, for his own personal retention. Thank you very much. If you look at A18, sorry, A19, I beg your pardon. This is the document that was sent on the 11th of February. So that was at 4:30 on the day in question.
19, did you say?
I said 19 at page 304. If you turn over, there is the letter that was then sent on the 17th of April. Middle paragraph of page 307.
Right. Tab number again?
It's tab 20, it's the following tab, Your Honour. So this is the letter under Article 50, setting out the reasons. That what is said halfway down the page, under the paragraph, you stated that. Second sentence says, you left the office with a number of items in a box, including the Elseco computer, which was damaged, and its hard drive deleted or destroyed. Request of Mr. Lemaire to box before you left. So there was a request that was made initially on the afternoon of the 11th of February. I believe that, and it was then returned by the 17th of April. In tab 20, it's at 307.
We have the letter, yeah. Which part of it, please?
It's the second page, 307. And if you look between the two hole punches, Your Honour, there's a paragraph saying you stated that you would spend. Second sentence and following. So
He left the office with the box on the 11th. Would that be right?
yes, he did. So, as I say, it's not just leaving the office with a box, it's what led up to that departure. The fact that there was this discussion with PW, that there was this discussion and attempt to introduce 5.2 million in. There was then a discussion between Mr. Lemaire and the accountant. Not our suggestion, it's his suggestion. He was asked to leave the room. He was then invited to come back in, although that is not addressed, and the judge finds to the contrary at paragraph 64D without reciting the evidence of Mr. Lemaire in that regard. he gives us one of the reasons that Brando should be distinguished, because the relationship here is not an ordinary one. I rely upon Neri and the paragraphs that I have shown you and the passage about the seriousness of the role played by the individual to elevate his responsibilities and indeed to justify the termination by reason of the fact that he wasn't an ordinary employee.
Answer me this question. Was there anything illegal in what Mr. Lee did up to the point that he was terminated?
When you say illegal, do you mean was it criminal?
Contrary to law.
Oh, well, it was certainly contrary to 9.2.
Sorry?
It was certainly contrary to 9.2.
What way, please?
Because he was seeking to prefer his personal interests to those of the company that he was charged to look after.
Why? Well, okay. But you are
And he had
arriving...
well, hang on,
sorry.
let me finish the submission. And moreover, he was also charged with making sure that his entitlement under the agreement was limited to an accounting procedure, which he full well knew was not that he was urging the accountants to adopt, and doing so would have given him a personal benefit. So do I point to that as being misconduct that would warrant termination for cause? Yes, I do. He knew what the contract provided. He knew what he was entitled to do. And on the last 3 days leading up to the termination of his employment, he tried to get these figures included into the accounts, the result of which, had that happened, would have been to give him a windfall of 5.2 million. Do I think that's looking after the interests of the company? No, I don't. Do I believe that it's grounds on which an employer could terminate for cause? Yes, I do. That was the submission. But then he leaves with a box carrying confidential information out of the company's premises. When asked by the CEO, could I see what you're taking, he refused to give it. And when he gives it back, eventually, he's wiped all the information.
All I wanted was chapter and verse for which particular law he has violated in doing all the things which you just complained about, other than 9.2.
Right. First of all, I don't accept that it is a test of contractual consideration alone. It is whether a termination for cause is warranted. There is clearly a duty of good faith and looking after the interests of the company.
But you haven't defined that duty in good faith, unless, of course, it's in your skeleton, and then you just point me.
With respect, I don't accept that I haven't defined the duty. I have taken you carefully to the decision of Neri. I have given you the analysis there. I have shown you the duty of good faith that is there referred to as the implied good faith term in the official case. I have said that that is imported expressly into the law of this contract. It is one that governed the employment relationship. And when looking at the conduct of a CFO in these circumstances, it is one that you can and should take into account. And the judge didn't do so properly because he didn't ask the right questions. He said that as a CFO, he was entitled to ask the accountants to consider anything, but he didn't go on to consider the other side of that inquiry, which was, if he was going to do that, was that inconsistent with the obligations that were placed upon him to promote the interests of the company and to abide by an accounting procedure under the CFA, which, if he knew existed, could not tolerate the inclusion of those and would not give him the benefit that he was asking for. In so doing, was there a conflict? Yes, there was. Should he have done it? No, he shouldn't. Was it a breach of good faith? Yes, it was. Now, that's the case.
Thank you. Very conveniently summarizes your entire argument in one spot.
Well, I mean,
very grateful for that.
But what I'm saying is that's on the inflation of the accounts. My point.
No, I'm just saying his behavior up to the point of the termination letter should identify the specific illegalities you relied on. You've just had a few minutes on your feet telling me exactly that, for which I'm very grateful.
Yeah, but it doesn't end there, because, as I say, the points are made in our skeleton at paragraph 23, which I took you to. So it is a combination of that.
Right, the first skeleton?
Yes, it's the one that we've looked at just now. And it starts at 23, which refers to the Brando position and the wiping of the laptop.
23.
And 24. 24 paragraphs A, B, and C, Your Honour. So those are the matters that we rely upon, and we say that they are incompatible with a CFO acting in accordance with 9.2, bearing in mind that he had a personal benefit under the agreement, which demanded an adherence to an accounting procedure that he, in the last days of his employment, was trying to evade, by suggesting that a different policy be taken that would give him a benefit. And then the behaviour that followed that at B and the threats.
But is there anything here in paragraph 24 and 25 that is not contained in what you just said to us?
No, it sets out the elements of the conduct that is relied upon. So, yes, it summarises the point that I've been making. Right. So, I was going through the reasons, and the first reason in my submission is not a ground for departing from the approach of Brando identified at paragraph 61 of the judgment. The fact that he had a special interest in the company's final accounting years did not give him the right to remove the company's data. Point B, the retention of the company property and data was at all material times a secondary reason relied upon by the defendant for termination. That is GM packaging. That is the case that I've taken you to. You don't hive these off into different grades, secondary and primary. You look at the conduct as a whole in its entirety. Point C, the fact that the mutually agreed date of termination was only 4 days hence. In my submission, if there is just cause, the fact that the contract itself may be terminated at a short period makes no difference. If there is misconduct which warrants termination for cause, that is something that can be relied upon at any time throughout the employment relationship. To do otherwise would be to hold an employee to a lower standard of accountability as the employment comes towards an end. And it would subject an employer to a higher threshold than would otherwise be the case. It is a standard that is applied uniformly throughout the employment relationship.
Relevant factor and what a reason? Something you take into account?
Well, again, I pose this question. On the facts here that the Chief Financial Officer, bound by the terms of the SCA, tries to do something that would give him a personal benefit, does the fact that the employment is going to terminate anyhow in 3 days detract from what was going on?
Well, it may work both ways, mayn't it, in the context? Yeah, doesn't it? You must look at it round, as you say.
Well, I agree that you should look at it in the round, but my submission is that the test as to whether something warrants termination is not time sensitive in the way that the judge has put it.
I follow that, but it's the second part of the test that it might be relevant to what a reasonable employer might do. In essence, what the judge appears to be saying is, well, you could. Doesn't say it in those terms, but that appears to be the underlying.
Well, my Lord, my submission is that here, looking at what happened, that a reasonable employer, given this man's position, given the benefit that he gets under the SCA, given the term of 9.2, and looking at it on this broader investigation, would have reached the conclusion that Brando, which would normally apply in this situation, there would be no reason not to apply it here. That's my submission. In terms of the fourth reason...
But just to get it on the record so as to remind myself when I come and relook at the transcript, probably would be a factor in your client's favor that even though it was 4 days to go, if your clients correctly terminated cause, then they would relieve themselves of certain financial obligations that they would otherwise have to pay him had he worked out his 4 days.
Correct.
In particular, the gratuity, right? I don't know about the notice
Well, the notice period, it was interesting because what the judge found in that case was that where there is a an agreed termination date, the employer is not subjected to pay the statutory notice because it is curtailed.
That's what I thought, and I was just sort of trying to measure that against the claim in his claim form that he wanted 90 days.
He didn't get that, and there was no appeal from that. But you're right. I mean, there was arguably an exposure in that regard and to the end of employment gratuity.
Would that have been the extent of the difference, arising from your client's, as it were, self-help, by terminating him prior to his agreed date of departure? They saved themselves. They would have saved themselves the gratuity. And probably the salary, isn't it? Because your clients didn't pay the 4 days, did they?
Yeah, there was obviously the small amount of salary that would be saved. The only question I have is the issue.
I don't know whether your termination would have meant forfeiture of the various other perks, benefits that he was entitled to, which is listed in his particular.
The answer is the only other one that I would have thought could have been would be the bonus payment, but there was a bonus for 2013 that was claimed, and I don't think there was one going. Only working out a small part of that year.
Isn't the bonus for the 2013 the point at issue, which is, or is it the bonus for 2015, which was going to be based on the 2013 account?
It was exactly. It was the bonus for 2013 that was not calculated until. That wasn't crystallized at that stage.
That's included in his claim. But that is not dependent on his dismissal, though. I mean, that's just an interpretation of the contract.
Your Honour's entirely right. That wouldn't be a saving that would be made. But the end of service gratuity of €48,000 would.
Page 3 or 4, it appeared they were.
Sorry, Your Lordship is
Page
referring.
304, third paragraph, second paragraph. I will.
Yes. Can I say I think that what then happened was that there were a series. That was one of the matters that. That was the.
Hence the 4 days in the.
Exactly. I think that is all I have to say. The only other thing I'd say on 65D, if I would, if I may, is. You see, at D, he goes on to say, the claimant had been excluded from a meeting with PwC, and in the absence of a proper investigation, I am inclined to find that the employer's conduct was unreasonable, which might, not did, have genuinely led the claimant to be concerned about the destruction of hundreds of emails which have been passed between him, PwC, Mr. Lemaire, and the accounts team. Now, one of the points that was taken by Mr. Lemaire in his evidence is that, well, this so-called concern about preserving evidence not borne out given the destruction of the documents. And if you look at his witness statement, A tab 21, he refers there to the destruction of the laptop memory and the operating system, and says that he continues to retain an external hard drive. It's page 332, which is the very end of the statement, before the signature.
Yes?
It's just the end of that paragraph where he refers to the destruction. Now, again, in his judgment, the judge does not address the destruction issue. Because whilst I accept that obviously conduct that took place after the dismissal falls into a different category, what it does is it may inform the genuineness of the explanation that is being given when the property was removed in the first place. And rather than wanting to preserve documentation, he may wish to get rid of certain information that was on the computer. Now, what is said by Mr. Leese is that, oh, there was a technical problem. And I tried to get that sorted out, and it didn't happen. Now, the judge doesn't address the destruction issue at all when he reaches his conclusion at the end of paragraph 65D. And again, in my submission, that is a matter which he ought to have taken account of and either said in clear language, I prefer the explanation of Mr. Leese and that he did, in fact, not wish to destroy the information on the computer. Gave back to the company was unusable, but... Or he should have said, well, that causes me to call into question what it was that he was intending to do when he took that from me. And the fact that he didn't give an explanation to the employer when asked is a factor I weigh in the balance. Now, none of that analysis is contained in the judgment. Together with the factual error, according to the evidence of Mr. Lemaire, that he was given the opportunity to return. Now, insofar that there were 2 points that were made by the claimant, Mr. Leese, which was that there was an imbalance between the employer and the employee. This is at paragraph 58.
Right, Mr. Hockhauser, just to kind of remind you, you're going to address us on 18.
Yes.
I want to keep an eye on the clock.
So can I just say that in relation to this, there are 2 points that the judge records as a submission, but he makes no findings on them. Insofar as he does record them, and they are at paragraph 58, that there is an imbalance of power between an employer and an employee, and secondly, that the DIFC rules on disclosure are different in entitlement to documents to that in Brando, and that would have to be a specific application for disclosure in a way that would not be necessary under the English system. Now, he doesn't rely on either of those reasons in his decision. He records them, but doesn't address them in his findings. Insofar as he does, we say there was no imbalance here, and the DIFC rules of disclosure give perfectly adequate remedies to individuals to ensure that documents are protected and produced.
Done a comparison of our RDC with the...
They're not identical, but there is certainly a right to obtain disclosure of documents in a way that would not justify an employee removing documents, as happened in Brando, as happened in this case.
Discovery isn't about justifying ex post facto. Discovery is about getting to the truth. Truth under RDC rules are more constrained in terms of cost efficiency and deference to civil law concepts than the English rules.
Well, what we say in relation to the disclosure issue can be seen in our skeleton.
Main skeleton, yeah.
Well, I just want to give you the precise reference. Yes, it's paragraph 28 at page 22 of A tab 3. I mean, as I say, it's not the judge doesn't actually say that he relies on this point. But all I'm saying is there is a submission that is recorded that is not addressed. And we, insofar as it can be inferred from the reasons that we say, that does not in itself justify a distinction of the Brando position. And indeed, he didn't identify it as such.
Distinction is very limited in print, where it can follow exactly the format of the
Absolutely.
IFC.
Absolutely. To the court. Absolutely. During case management. And in their skeleton, a primary submission is paragraph 27, which I will read you. Importantly, the judge found, with the exception of retention of company property, the appellant had failed to establish the allegations relied upon. Now, I don't accept that for the reasons that I've identified, and I've given you the references on those. Insofar as his finding at paragraph 48, in which he says the way in which Mr. Least posed the questions did not reach the threshold of gross misconduct, and the transparency in its approach suggested he acted in good faith, I raised 2 points. Number one, what about the 2 communications that were sent behind the back of Mr. Lemaire just as he was about to leave the employment of Elseco? And what the judge singly fails to do is to take any account as to why Mr. Least was asking those questions and inviting PwC to take those additional sums into account. Now, I can see that if he had no vested interest in the outcome of the interrogation, then one could see that there was no cause for complaint. But he was contractually constrained to have an entitlement by reference to the 2010 accounting process. And as the judge acknowledged at paragraph 48, what he did flew in the face of that. So you don't just ask, were the questions being asked, but why were they being asked? And was the asking of those questions in a way that would have conferred the personal benefit, one that was a proper course to take? So, to summarize, the terms by which Mr. Least was bound were contained in the SCA. The accounting method that was agreed to be adopted was included within it. There were communications not copied to Mr. Lemaire at 45 C and D. There was removal of the company property, including data and information. There was refusal to permit inspection, together with the other matters at paragraph 88. And had the proper test been applied without subjectivity, not elevating the standard, and including the reasonable employer approach, it is our submission that one would be driven to the conclusion that this, and that the judge fell into error in not reaching that conclusion. Great reliance is placed upon the court in Macduff. I would invite you to have regard to the fact that if you look at paragraphs 28, 29, and 33, acquiescence was prayed in aid there as being reasons why the just cause termination could not be relied upon. That is not this case. And that what applies here is the GM packaging case. I therefore turn to Article 18.2. I had no further submissions to make, unless there is anything that I can assist you further with.
Thank you. Move on to 18.2.
I will. This is dealt with in our original skeleton, please, at paragraph 36. And there are essentially 2 primary points that I would make here. When one looks at Article 18.2, one has got to construe it in a way, if possible, that does not give rise to absurdity. In this case, the judge, at paragraph 165, when looking at the law, said that it could lead to harsh and absurd consequences. And he had earlier set out at paragraph 159, page 38, the problems that arise. Now, you'll need to turn up, please, the language of Article 18.2. That is found in Volume C. Tab 6, at page 1250. And if you look at the judgment at the same time at 159, now what is said in the opening line is, if an employer fails to pay wages or any other amount owing to an employee. So arguably, if you have, for example, the expense of a taxi that is outstanding, the penalty that you get for non-payment is a daily wage for every day of non-payment. There is a 6-year period in which an employee can bring a claim. The longer he waits, the longer he will get a daily penalty. Where the matter is...
The longer he waits for what?
To bring the claim. So suppose there is a dispute that somebody says, I've dismissed you for cause. And the employee says, not at all. I am entitled to 90 days' notice and an end of termination gratuity. The matter is not resolved, it goes to the courts. It has a 6-year period in which he can bring his claim. The longer he waits to bring it before the court, if it's right that the penalty starts to accrue on the 15th day after the non-payment, then he will get a gratuity for a 6-year period, and then you've got the trial. And in this case, as I say, there was a very long period between the trial and the adjudication. So on that analysis, an employee claiming a 90-day notice period can get a penalty payment equivalent for a daily wage for up to 6 years. Now, can that...
So it takes him a number of years to process it. The employer knows that there's a claim. The employer should know how much he owes his employee, and he just pays the amount that he thinks is lawfully due. If he gets it wrong, that's when the thing bites on him. Well, he has to make very sure that he pays the right amount.
Well, but the difficulty with that, Your Honour, is this. If you go back to the judgment, in my view, the wording of Article 18.2 of the Employment Law can lead to harsh and absurd consequences, particularly where the conflict between parties reaches the court, and this is made even worse if the dispute itself is over wages. So, for example, you say, well, an employer needs to pay the money that is due. And his case is, I have a genuine belief that this is a termination for cause. Let the courts decide. Now, in those circumstances, is a DIFC employer obliged to assume that he is going to lose and to pay the employee anyhow? In which case, what will happen? How can there be a determination of the dispute because the debt is satisfied? The employee has got what he's asking for. There is no longer a claim. So effectively, it deprives, that analysis would deprive an employer of being able to contend that there is a termination for cause, genuinely, and then stand to be subjected to a penalty of a daily wage for however long it is until the claim is brought and disposed of. Now,
if he gets it wrong.
If he gets it wrong. But the alternative would be to find, as we submit, that failure to pay has some different meaning than simply a non-payment, and that it means either that there is an admitted payment or an adjudication by a court, whereupon payment has to be made. And the way in which I put it in our supplemental skeleton is that there is a case called Woodar and Wimpy, excuse me, in Volume D of the authorities, and it was considered in a case that...
I know Woodar and Wimpy.
And the case where it was considered was by Sir John Chadwick in a case called Lidl and Hertford Foods. That's in your bundle at D20.
Right. Is it C?
D20. It's the continuation of the authorities at 1803. And there was an issue about the battle of standard terms. Each party to a sale of goods contract wanted to rely on their own standard terms. And there was questions about being able to terminate the contract and whether or not there was a repudiatory breach, whether each party had been in repudiatory breach, and the circumstances in which adopting a position would be taken to be an intention not to comply with the contract. So if you look at page 1811, first issue raised by the appeal, this is the judgment of Lord Justice Chadwick, is whether the judge was right to hold that the contract made on the 13th of December was made on Hertford's standard terms and conditions. And then at 17, judge below found that it was. Hertford sought to uphold the orders on grounds set out in the respondent's notice, and then it sought to introduce a further ground. And that is set out in the balance of paragraph 17. Paragraph 25, 1814, Court of Appeal reversed the judge on the first issue. I think he was wrong to hold that the contract made on the 13th of December 1996 was made on Hertford's standard conditions of sale. The correct conclusion is that the terms of the contract were such as expressly agreed or are to be implied by law. So nobody's terms were incorporated. And then at 44, passage that we rely upon, it is not, I think, in doubt that a party who insists that he will only continue with the contract if the other party accepts a new stipulation as to mode of performance may be held to have repudiated his obligations under it, thus enabling the other party to treat the contract as terminated, and as the Total Oil and Thompson Garages case. But it doesn't follow that a party will be held to have repudiated his obligations. He has an honest, although mistaken belief that the stipulation that he insists on is a new stipulation, rather one of the terms on which the contract was made. And there is reference to Woodar and Wimpy. In such a case, citing the passages from Lords and Lord Keith in their the law requires that there be assessed not only the other party's conduct, but also objectively considered its impact on the other party. And he finds there that there was, at paragraph 47, looking at the correspondence, cannot be said that Lidl manifested by its conduct an intention to abandon the contract. On the contrary, it demonstrates an intention to proceed, but upon terms which differed from those upon which Hertford was willing to proceed. For the reasons I've set out, I'm satisfied. Lidl was entitled to reject Hertford's contentions that its terms applied. It was not entitled to insist on performing the contract in accordance with its own terms. In relation to the question actually in dispute between the parties, whether or not Lidl was entitled to debit Hertford with the additional costs, it was Hertford Standard's terms and not Lidl's that were relevant. And therefore, the appeal was allowed and Lidl succeeded. Now, I accept entirely that we are looking at something rather different here, but what I say is that in a contractual construction, and by analogy, the construction of an article here, one is entitled to look at something called the Golden Rule. The Golden Rule we summarise at length, and I'm sure that you were addressed on it in the Frontline case, Lord Wensleydale and following. You are entitled to interpret a provision of a statute in a way that doesn't result in an absurdity, and to import into the word fail something more than simple non-payment is, in my submission, an entirely acceptable course of achieving the purpose of the employment law. And let us not forget what that purpose is. I mean, there is a tendency to get embroiled in the detail and to forget the overriding objective of the legislation. And can we look at that at tab 6 at 1245?
Tab 6 or
Tab 6, and it's the
In what
general
bundle?
part 1. And 3 tells us what the purpose of the law is. The purpose of the law, at Article 3, 1245, is to provide minimum employment standards to employees based within or who ordinarily work within or from the DIFC. Promote the fair treatment of employees and employers, and to foster employment practices that will contribute to the prosperity of the DIFC. Now, in my submission, giving an employee a windfall benefit of up to 7 years daily wage penalty is inconsistent with that, and an interpretation of the word fails in a way that would subject it to a judgment being made or an admission would deal with the matter. But in addition to that, we submit that there is a clear case made out for imposing within that the exercise of a discretion. Now, there is one case where the court, in opposition to the stance taken in Frontline and the present case, has adopted that discretion. The judgment is not full, but it is in the bundle, and it's C17. Look at that. Were you shown this case? This is the case of Dakari and Dalmatia. Is that a matter that was before you on the Frontline case? It's a very short judgment by His Excellency Justice Al-Soali. Effectively, there was a claim that was brought for non-payments of dues and benefits. And if you look at paragraph, I won't use the letters, I'll use the numbers. You'll see at paragraph 3, the defendant refused to pay the claimant, which led the claimant to file the case before this court. Paragraph 5, she had not received her dues and benefits within the 14 days following the end of her contract in breach of Article 18.1. The claimant had specified her claims as unpaid salary for 1 month, compensation in lieu of her vacation leave, ticket flight allowance, and interest for delay payment. And then this, I think, is a reference to Article 18.2, compensation for failure to pay wages on time. Now, the judge at paragraph 9 says, I've examined both parties' submissions, and I've found the final payment of dues submitted by the defendant is reasonable. The claimant is therefore entitled to 20,569 dirham. Furthermore, I found the evidence submitted by the claimant is neither sufficient nor reasonable to establish that the defendant is contractually or legally liable to pay any extra amount beyond what has been decided, and that must be a reference to paragraph 9 of this order rather than 8. So, quite clearly, in that case, the court did not award a penalty payment of a but there are no reasons behind it. We say the following in our skeleton, and I will summarize it very quickly. The DIFC courts have been prepared to exercise discretions before. We give an example, and again, it's not exactly on point, but in my view, it is of assistance. If you look at our skeleton, paragraph 71, that's the main skeleton, A tab 3, page 37.
A, bundle.
It's bundle A, tab 3, and it's at page 37. Now, there is a provision under the arbitration law, Article 13, which enables a court to stay or dismiss an action where there is a matter that is the subject of an arbitration agreement. In a decision of Sir Anthony Coleman, at paragraph 74, which is the Injazat case, for your note, that's at C16. The defendant sought to stay the DIFC court proceedings on the grounds that the parties agreed to arbitration seated in London. The application was refused. I beg your pardon, it was Sir David Steele, not Sir Anthony Coleman. The application was refused because the arbitration law only applied to DIFC seated arbitrations. And the court said, we have no discretion, we cannot allow this, there's no other basis on which to do it. However, there was then the following decision, David Williams, this is at C15, in the electromechanical services case, which declined to follow that approach. And if you look, please, at C15, at page 1430. And it's paragraph 96 that I would draw to your attention, where he found that there was a discretion and he wasn't going to adopt the approach, and he relied on the public policy considerations. If you look, please, at paragraph 116, promotion of the DIFC as a jurisdiction supportive of arbitration as an expeditious and cost-effective dispute resolution process. Now, it is us, we cover this pretty comprehensively in the skeleton and the supplemental skeleton. But we say that by importing a discretion into Article 18.2, it would be entirely consistent with Article 3 of the employment law. See paragraph 85 of our skeleton, A341. It would reflect the approach that is taken, and I accept the wording is different, in Article 40 sub 1 of the DIFC law of damages and remedies. See paragraph 44 of our skeleton, A329. It would be entirely consistent with Article 94 of the UAE Constitution. See paragraph 80 of our skeleton, and it would mean that a judge would not have to take a course that would be absurd or unjust.
Right. This paragraph 80 is
I believe so. That's my note. Yes, it is.
Article 94 of the UAE Constitution.
And what we say is that in those circumstances, the judge would be able, in accordance with what he is charged with doing, to render a result that does not give rise to unjust or absurd consequences. It would be consistent with Rule 1.6 of the rules of the DIFC Court, which is the overriding objective. See paragraph 78 of our skeleton. And it would also be consistent, for example, with the power of the DIFC Court to moderate excessive contractual penalties. Because I realise that in this jurisdiction, this court does not follow the approach of the Supreme Court in the Cavendish Square holding case, and that penalties, if deemed such, can be moderated. The court has got the power to reduce those. Now, if it has that sort of power in this jurisdiction, in my submission, an approach that would import a discretion would not be inconsistent with the matters that I've drawn to your attention. Now, I know that Justice Giles, at paragraph 335 of the Frontline case, says, well, hang on a sec, this is not construction or the golden rule. This is rewrite, and rewrite goes a step too far. So my point on that is that rewriting a contract as a means of construction is one that has been done at the highest authority, and namely ICS and West Bromwich Building Society, a case which I happen to lose 4-1 in the House of Lords. I like very much the judgment of Lord Lloyd, but unfortunately his was the only one in our favour. Could I take you to that very briefly? If it's loose in your volumes, I handed it up to you as the third authority. I'm sure you've had these passages cited to you many, many times. Lord Hoffman's judgment in the Weekly Law Reports of 1998.
Citation, Dean?
This is the loose authority that I handed up this afternoon.
Carry on first. Probably know it by heart anyway. Go on.
And the passage that it was in Lord Hoffman's speech at 906, but the material paragraphs can be seen at page 912. And what happened was the judge was prepared to reconfigure the wording of the clause. And you can see the way in which it was done. This is at letter E. And what is said there by Lord Hoffman, rather disparagingly of Lord Justice Leggatt's judgment, in the Court of Appeal, Lord Justice Leggett, on the authority of Through the Looking Glass, said that the judge's interpretation was not an available meaning of the words. Any claim, open brackets, whether sounding in rescission for undue influence or otherwise, close brackets, could not mean any claim sounding in rescission, open brackets, whether for undue influence or otherwise. And that was that. He was unimpressed by the alleged commercial nonsense of the alternative construction. It is quite clear, therefore, and the House of Lords upheld the judge below. There were the well-known contractual construction principles then set out. At letter F, he says, "My lords, I will say at once that I prefer the approach of the judge." And he then set out his well-known principles, which have been chewed over for many years thereafter, down to 913, letter E. The point I wish to make is that when one comes to consider the approach in Frontline, one has to have regard that looking at the Golden Rule test, if it does produce an absurd outcome, if there is an element of repugnance, if it is inconsistent with the rest of the statute, and I pray and aid Article 3, then it is possible for this court to interpret that article in such a way that does not produce absurd and unjust results. Now, I accept that that would entail amending the wording. And if you look at Article 18.2, the way in which the article would have to be amended would be if an employer fails to pay wages or any other amount owing to an employee in accordance with Article 18.1, then you would have to include the words, the court may order the employer shall pay the employee a penalty up to the equivalent of the last daily wage. And in that way, you would be able to import a discretion that would prevent the occurrence of unjust and absurd results, which would be entirely in keeping with Article 3. There is a secondary argument that was advanced in the skeleton. If you look at the definition of arrears, and we address this at page 30 of the first skeleton, A3, page 30, and it's paragraphs 45 and 46. It's page 30.
Sorry, the paragraphs are?
It's paragraph 45 and 46, Your Honour. That is on the true meaning of the words arrears. I confess I have some difficulty in urging those submissions on Your Honours. It seems to me that that would be going a step too far over and above the language of the provision. I rely upon the alternative argument, and again, adding to 48, paragraph 48, the additional words is clearly sensible in a way of limiting the penalty, but were you to take the discretionary route that I've suggested in the wording, those words would be unnecessary. What that was intended to do was to indicate, for example, if you've got a taxi fare of 20 dirham owing, it would be absurd to impose a daily wage penalty for non-payment of that, and that what it should reflect is the taxi fare. And it's quite clear that the draftsman of this legislation used the words or any other amount owing, but that is not reflected comparatively in the penalty that is imposed. So what that was inviting the court to do was to limit the penalty to correspond to the default. So if I've got a 1 dirham expense chit, I don't get a penalty of a daily wage for non-payment of it. And so it was suggested that one way around that was to reflect the words or other amount owing in the penalty that was included. But in my submission, a more elegant way of dealing with it, and more in keeping with Article 3 of the employment law, would be to use the wording that I have just outlined to your lordships.
Bottom, underlined in paragraph 48?
No, those are the ones that that's very much a secondary approach that we would invite you to
The one
take.
that you're pressing?
The one that I'm pressing you to take is the one that I just outlined, which was to add in the second line of Article 18.2 the words, the court may order the employer shall pay a penalty, and then after the words penalty, add the words up to the equivalent to the daily last wage.
Is that in your written skeleton?
No, it's not.
We'll have to read the transcript for that. Okay.
I beg your pardon?
We'll have
Yes.
to read the transcript.
Thank you
for
very
that.
much.
Or maybe you can just give us a note.
Of course I will. Of course I will. So, in essence, my submission's on 18.2 that the word fails must have a meaning beyond non-payment, and on its proper construction, Article 18.2 should confer a discretion on the court through the application of the Golden Rule. I see that it is now 5:29. Could I thank the court for sitting so late to hear these submissions?
Well, obviously, you're going to take most of the day tomorrow, but I think we have to revise the hearing hours because.
Could I just mention to you, for your note, that we deal with the Article 18.2 point, paragraphs 36 to 90, and in response, in our reply skeleton, at paragraphs 26 to 40. But that will be a document you won't yet have seen. But I have sought to summarise the arguments that are contained in it, Your Honour.
Are you going to give us this slip?
I will certainly do that overnight, so you will have that first thing tomorrow morning.
Now, as I see your plan of work, tomorrow, Mr. Lee's taking the whole morning. And what I'm thinking is, well, I'm telling you, I'm sorry, is that after lunch, I think we have to have a hard stop at 4 p.m. So 2 hours after lunch, and on the face of it, distributed parties on some other proportion.
So we finish at 4 tomorrow.
Or I have a plane at 5:30. I have to leave, at 5:30 to catch a plane.
What I will do is I'll discuss with my learned friend how we will divide that up.